Maloba Veleva, Chapter 25. 1. The following law applies when a person gives a loan to a colleague and afterwards the third party says, I will act as a guarantor. The lender, you sue the borrower, and the third party says, let him go. I will act as a guarantor. The lender was strangling the borrower in the marketplace, and the third party says, let him go, I will act as a guarantor. The guarantor is not obligated at all, even if the prospective guarantor says in the presence of a court, I will guarantee the money, he is not liable. If, however, he formalizes his commitment to guarantee the money with the kin, he becomes obligated in all the above situations. This applies whether the kin was made in the presence of a court or together with the lender alone. 2. However, if the guarantor told the lender when the money was being given, lend him and I will be the guarantor, he becomes responsible. In such a situation, the kin is not necessary. Similarly, if a court appointed him a guarantor, he becomes liable even if he did not affirm his commitment with a kin. For example, the court desired to expropriate property from the borrower, and the person told him, let him be, I will guarantee the debt for you. Since he receives satisfaction for being trusted with a court, he accepts a binding commitment upon himself. 3. When a person lends money to a colleague because of the commitment of a guarantor, although the guarantor becomes responsible to the lender should not demand payment from the guarantor first. Instead, he should demand payment from the borrower first. If he does not pay him, he should return to the guarantor and collect payment from him. When did it apply? When the borrower does not own property. If whoever the borrower does own property, he should not collect the debt from the guarantor at all. Instead, he should collect from the borrower. If whoever the borrower is a man of force, the court cannot expropriate money from him, or he refuses to come to the court. The lender may collect payment from the guarantor first. Afterwards, the guarantor will make a reckoning with the borrower. If the guarantor can extract payment from him, he should. If that is not possible, the court should place the borrower under a ban of ostracism until he repays the guarantor. 4. Although the lender makes a stipulation with the guarantor and tells him, I am given the loan on a condition that I can collect debt from whoever I desire. If the borrower possesses property, you should not collect debt from the guarantor for his stipulate. I'm giving the loan on a condition that I can collect debt from whoever I desire first, or the guarantor was a cobbler. The lender may demand payment from the guarantor or this cobbler first. He may collect payment from them, although the borrower possesses property. 5. Who is considered to be an ordinary guarantor? Who is considered to be a cobbler? If the person is given the loan, and I will give you, is considered to be a cobbler. The lender has the option of seeking repayment from him, even though he did not explicitly stipulate a condition that I can collect debt from whoever I desire first. If, however, he tells him, lend him and I will act as guarantor. Lend him and I will pay you. Lend him and I am obligated. Lend him and I will give. Lend him and I will act as a cobbler. Give him and I will act as a cobbler. Give him and I will pay. Give him and I will obligated. Give him and I will serve as guarantor. All these are statements that cause him to be considered a guarantor. The lender may not demand payment from him first, nor may collect payment from him in a situation where the lender possesses property, unless he stipulates on the condition that I can collect from whomever I desire first. 6. When a person guarantees a wife's ksuba, he is not obligated to pay even if he affirms commitment with a kin. The rationale that he performed a mitzvah and did not cause her financial loss. If a father guarantees his son ksuba and affirms his commitment with a kinyan, the obligation is to establish a person who becomes a cobbler for a ksuba is liable. 7. The following was applied when the Reuven sells the ship in the field and Levi accepts financial responsibility for. Levi is not considered responsible for this. Is an asmachta. If he affirms with a kinyan, his commitment to pay the money involved in the sale, whenever demanded to do so by Shimon, he is obligated to do so. My master is ruled in this manner. 8. Similarly, if a guarantor or a cobbler made a conditional commitment, they do not become obligated, even if the commitment is affirmed by a kin. This rationale is that this is an asmachta as implied. For example, the guarantor told him, give him this loan, I will give you this and this, will give him the loan, and I will give you if this and this will take place, or if it will not take place. The rationale is that whenever a person undertakes an obligation which he is personally not liable and makes it dependent on a condition, if this takes place or this is not place, he never makes a wholehearted commitment or kin, and therefore he does not become liable. 9. When two people take out loans from the same person and record their debts in the same promissory note or together purchase a single article, they are considered as having guaranteed the other person's commitment, even though they not explicitly agree to do so. The same law applies when one of a group of partners undertakes a loan or makes a purchase for the partnership. 10. When two people both commit themselves to guarantee a debt taken on by one person, when the lender comes to collect payment from the guarantor, he may collect from either of them as he desires. If, however, one of them does not possess the entire amount of the debt, the lender may demand payment of the remainder from the other guarantor. 11. If one person guarantees debts of two different individuals, when the lender comes to collect payment, he should tell the guarantor which of the two debts he is paying, so the guarantor will be able to seek reimbursement from the debtor. 12. When a person tells a colleague, guarantee a debt for so-and-so for this and this amount, and I will guarantee the sum to you, as if he tells him, lend the money and I will guarantee the debt, just as the guarantor becomes obligated to the lender. The second guarantor becomes obligated to the first guarantor. The same laws that govern the relationship between the guarantor and the lender govern the relationship between the first guarantor and the second guarantor. 13. The following opinions were stated with regard to a person who did not limit the extent of the commitment he made to serve as guarantor. For example, he told the lender, give him whatever you give him, and I will guarantee it. Sell to him, and I will guarantee it. Lend to him, and I'll guarantee it. There are guidelines rule that even if the other person sells 10,000 zuz worth of merchandise or lends 100,000 zuz to the person named, the guarantor becomes responsible for the entire amount. It appears to me by contrast that the guarantor is not liable at all, since he does not know what he undertook the liability. He did not make a certain commitment and did not obligate himself. These are the words of reason that a person of understanding will appreciate. 14. When a person tells a colleague, lend him, I will guarantee the borrower's physical person, he did not make a commitment with regard to the money itself. What he meant was, whenever you want, I will bring him to you. Similar principles apply when, after a lender makes a loan and demands payment, the person says, let him go. Whenever you lodge a claim against him, I will bring him to you. He affirms his commitment with a kin. The argument will rule that if the guarantor does not bring the borrower to court, the guarantor is obligated to pay. If there are, however, others who rule that even if he made a stipulation saying, if I do not bring him, or if he dies or flees, I'll be obligated to pay, the guarantor does not become liable for this. Is an asmachta. I favor this reasoning. Hilchos Mloa Veleva, chapter 26. 1. The following law applies when a person gives a loan to a colleague that is supported by a promissory note. After the witness has signed the promissory note, the guarantor comes to make the guarantee for the borrower's debt. Although his commitment was affirmed by a kin, and thus he became obligated to pay at 6 pay when the lender comes to expropriate money from the property of this guarantor. If not expropriate property that has already been sold. Different laws apply if the witness was mentioned in the promissory note itself before the signature of the witnesses. If they wrote so-and-so with the guarantor, the lender may not expropriate property that has already been sold because the guarantor's name is not associated with that of the borrower with regard to the loan. If whoever the promissory note states so-and-so borrowed such and such an amount from so-and-so, and so-and-so guaranteed the loan, the guarantor affirmed his commitment with the kin, and then the witness signed the promissory note. The lender may expropriate property that has already been sold. The rationale is that the guarantor's name is associated together with that of the borrower in the promissory note. 2. When the lender demands payment from the borrower and discovers that he does not have property, he may not expropriate payment from the guarantor until 30 days after the guarantor became obligated to pay. The legal power of the guarantor should not be less than that of the borrower himself. This halachic authority is ruled in this manner. If whoever the lender made a stipulation with the guarantor about this matter, that stipulation is followed. 3. When the lender comes to demand payment from a borrower, the borrower cannot turn the lender away, telling him to go to the couple because you have the right to demand payment from him first. Instead, the lender may demand payment from anyone he desires first. If whoever the couple took the money from the lender and gave it to the borrower was nothing to do with the borrower. If the borrower was in another country and the lender cannot notify him that the borrower died and left heirs below the age of majority whose property the court cannot attach, the lender may demand payment from the guarantor first because the borrower is not at hand. 4. When the lender demands payment from the borrower and discovers that he has become impoverished, he may not demand payment from the guarantor until the borrower takes an oath that he is bankrupt as ordained by the later sages. The rationale that we fear that the borrower and the lender might be trying to obtain the guarantor's property through deception. 5. The following law applies when a person has guaranteed a colleague with regard to a loan supported by a verbal commitment to loan. The lender comes to demand payment for the guarantor and the borrower is overseas. The guarantor will tell the lender bring proof that the borrower did not pay you and I will pay you. 6. When a guarantor takes the initiative and pays the debt of the creditor, he may come back and collect from the borrower everything that he paid on his account, even though the loan was supported by a verbal commitment to loan or was not observed by witnesses. When did it apply? When at the time the guarantor made his commitment, the borrower told him, become my guarantor and pay. When whoever he acted independently became a guarantor or cobbler, or the borrower told him guarantee the debt for me, but he did not give him the authority to pay for the debt. If he pays the debt, the borrower is not obligated to pay him anything. Similarly, if a person pays a promissory note of a colleague without that colleague's knowledge, even if it is a debt for which the security was taken, the borrower was not obligated to pay him anything. Instead, he may take his security without paying anything. The other person forfeits his money. The rationale is that perhaps the borrower would have been able to appease the lender and have him waive the debt. The borrower was the borrower dies, and the guarantor takes the initiative and pays the debt before he notifies the heirs. If it is known to us the borrower did not pay the promissory note before he died, e.g., he admitted the debt on his deathbed, he was placed under the ban of ostracism for paying to pay, and he died under the ban of the due date of the loan that did not arrive, he may collect from the heirs everything that he paid. When the lender was a Gentile, the heirs are not obligated to pay the guarantor. The rationale that the parent might have given the guarantor the entire debt for which he was responsible. For the Gentile demands payment from the guarantor first. For this reason, the guarantor paid the Gentile voluntarily before he notified the orphans. If whoever he notifies them the Gentile has demanded payment from him and that he is paying, the heirs are obligated to pay. 7. Whenever a guarantor comes to collect what he paid, whether it comes to collect from the borrower's heirs or from the borrower himself, he must bring proof that he paid the debt. The guarantor's possession of the promised note is not considered proof, or perhaps the promised note fell from the lender's hand and the guarantor did not pay him at all. 8. In all claims to be mentioned and in all similar situations, we follow the principle whenever a person seeks expropriated property from a colleague, the burden of proof is upon him. A. A person tells colleague, you've agreed to serve as a guarantor for me, and the alleged guarantor denies accepting the obligation. B. The guarantor tells the borrower, you gave me the license to act as a guarantor for you and to pay, and the borrower tells him you acted as a guarantor on your own initiative, or you were not a guarantor at all. C. The guarantor said, I paid the debt in your presence, the borrower said he did not, or he told him, I've already given you what you paid. Or D. The lender told the guarantor, you guaranteed 200, and the guarantor said, I only guaranteed amount. Alternatively, the defendant should take a phos or a scriptural oath if he agreed to the portion of the claim, as is the law with regard to all financial claims. 9. The following principle applies when a servant or a married woman borrows money or guarantees the debts of others and is obligated to pay. When the servant is freed and the woman is divorced or widowed, they must pay. 10. If a minor borrows, he is obligated to pay when he attains maturity. We do not, however, write a promissory note against him. Instead, even though it was affirmed with a kinyan, the loan has the status of a loan supported by verbal commitment to loan. The rationale is that a kinyan undertaken by a minor is of no substance. 11. In a situation where a minor guaranteed others, again, in rule that he is not allowed to pay even after he attains maturity, the person who lent his money because the minor's word forfeits it. The rationale is that when a minor does not have the intellectual responsibility to obligate himself in a manner which he is not liable not through becoming a guarantor, nor through other similar means. This is a ruling of truth, and it is fitting to rule in this manner. 12. When a woman takes a loan that is supported by a promissory note or undertakes a commitment as a guarantor of a promissory note and then marries, she is obligated to pay even after she marries. If, however, it is a loan supported by a verbal commitment to loan, it should not be repaid until she becomes divorced or widowed. The rationale is that her husband's authority is that of a purchaser, as we have explained in several sources. If, however, the money that was given as a loan is in her possession, it should be returned to the borrower. Hilchos Mloa Veleva, chapter 27:1. No matter what language in which characters a legal document is written in, if it is written according to the regulations for Jewish documents that prevail among the Jewish people, i.e., cannot be forged, nor is it possible to add or detract from the content of the document, and witnesses are Jews and they know how to read it, it is acceptable and may be used to expropriate property that has been sold. All documents that are signed by Gentiles by contractors are not acceptable except for deeds of sale and promissory notes. For the latter to be acceptable, the principal must count the money in their presence. They must write on the legal document, not present so and so counted out for so and so the money of the sale or the money for the debt. This applies provided that they were prepared by their legal authorities. If, however, the documents were prepared in their courts without being authorized by their judges, they are of no value. Similarly, Jewish witnesses must testify the Gentile witness who signed the document, the judge who authorized the signature, are not known to accept bribes. Minnesota looking at you. Okay. If legal documents composed by Gentiles lack any of these qualifications, they are considered charged. Similarly, legal documents acknowledging an obligation, deeds recording presence, compromises, and waivers of obligations are considered charged, even if they are composed with all the above qualifications. The master's rule that even promissory notes composed with them that state that the money was given in their presence are unacceptable. They accepted only deeds of sale when the money was given in their presence and do not accept this ruling. If the Jewish judges do not know how to read the legal document prepared by the Gentiles' authorities, they should give it to two Gentiles, each one outside of the presence of the other, and have them read it. Thus, each one of them is reading as is ordinary practice. The document may be used to expropriate property that has not been sold. It may not, however, be used to expropriate property that has been sold, because it does not become public knowledge, for the purchaser will not know of legal processes carried out by Gentiles. 2. When promissory note that was signed by a Gentile witness was given to a borrower, or was given by the borrower to the lender, or by the seller to the purchaser in the presence of two Jewish witnesses, it is acceptable and may be used to expropriate property that was not sold, even though it is not authenticated by the local Gentile authorities and was not prepared according to all the stipulations mentioned above. The provided the witnesses into whose presence the document was transferred were able to read it, and they read it when it was transferred and was prepared according to the regulations for legal documents prepared among the Jewish people, i.e., that it was composed in a manner that cannot be forged, nor is it possible to add or detract from the content of the document. Why is not acceptable to use to expropriate property that has already been sold? Because it is not a matter of public knowledge. 3. The following regulations prevail for legal documents among the Jewish people. All legal documents repeat the content of the legal letter in the last line, because we do not take into consideration what was written in that line. The rationale with respect, the witness signed a line away from the body of the document that this falsifier came and wrote on the empty space of this line. 4. When the witness has signed 2 lines or more from the conclusion of the writing, document is not acceptable. If they leave less open space than this, it is acceptable. The 2 lines mentioned refer to the lines according to the handwriting of the witnesses and not according to the handwriting described. The rationale is that any person who forges tries to imitate the handwriting of the witnesses and not that of the scribe. The space of the 2 lines includes the lines and the space between them, i.e., the space necessary to write a lamed above a final sof. If there was a space of more than 2 lines between the signature of the witnesses and the text of the document, they filled the space between the text and the signature with the signatures of unacceptable witnesses and relatives. It is acceptable for this manner, it cannot be forged. If the space is filled with lines of ink, it is unacceptable for perhaps the witnesses signed for the lines of ink and not for the body of the document, and if the document, the signatures of the witnesses were on one line, it is acceptable. 5. If a legal document was written in one line, the witnesses signed on another line, it is unacceptable. If the possibility the witnesses had signed on one line away from an acceptable legal document. And afterwards, the person cut away that entire legal document and wrote the present document on that line. Thus, the witnesses were signed upon it. A similar suspicion could arise when the document and the signatures of 2 witnesses were on one line, 2 other witnesses were signed on the second line, and the maker of the legal document says, I need to increase the number of witnesses. We do not verify the authenticity of the document based on the signature of the witnesses below on the second line, but rather on the signatures of those above. We fear that possibly there had been another document written originally. It was cut off, and the present document and the signature of the 2 witnesses were written on the line between it and the witnesses who signed below. 6. The validation of the authenticity of the signatures of the witnesses of the court should be positioned next to their signatures, next to the one of the sides of the legal document on its back, or on its back opposite the text. If there was a space more than one line between the statement of validation and the legal document, it is invalid. We fear that someone might cut off the document that was validated and forge a new document, the signature of the witnesses in that one line. Thus, the validation would be on the forged document. 7. If the court wrote the validation more than 2 lines for the legal document and filled the entire empty space with lines of ink, the validation is acceptable, for there is no possibility of forgery, and we do not expect the court would sign the validation and realize, but rather of the legal document itself. 8. Whenever words are written on surface where there had been erasures, the scribe must write a validation of each of these portions at the end of the legal document, saying this and this letter, this and this word, or this and this line were written on the surface where there had been erasures or are attached between the lines. Everything is valid. The erasure is in the place where the document states Shadir Vikaya, and it is the size that it takes to write these words. It is not acceptable even if the scribe validates these words were written on the erased surface. We fear the person might have erased the word Shadir Vikaya and then written a false statement and then validated the document in the space between the document and the signature of the witnesses. 9. When both a legal document and the signature of the witnesses that are written on the surface where there had been erasures, it is acceptable if one might protest saying the person in the possession of the document might erase it again or write a text that befits him, that argument can be answered, for it's possible to differentiate between a service that has been erased once and that has been erased twice. If one put is saying maybe the person erased only the service where the witnesses would sign twice, and then after writing the legal document above the twice erased service, having the witnesses sign it, he erased the document and vote wherever he desired. In such situation, the document, the signatures of the witnesses appear the same because everything was erased twice. This part is untenable because it is already ordained that the witnesses should not sign the document written on a service where there had been erased unless it was erased in their presence. 10. When a legal document and the signatures of the witnesses are both written on a service where there had been erasures and the validation of the authenticity of the signatures was written on paper that had not been erased, we did not validate the document because of the signatures of the witnesses who validated it previously, because the signatures of the witnesses who signed it originally. The rationale is that it is possible the validation document was written very far from the document itself, and the space between them was filled with lines of ink. We suspect the person in possession of the document was cut off document itself, erased, lines of ink, a forged document, and the signatures of the witnesses on that portion had been erased. 11. When the document is written on paper that had never been erased, and witnesses signed the service where there had been erasures, it is unacceptable. We suspect the person might erase the document that the witnesses signed and replace it with a forgery. Thus, the document that the witnesses the signature will be on paper with erasures. If the witnesses wrote, we the witnesses signed the portion of the paper where there were erasures, and the document was written on a portion of the paper that was never been erased, the document is acceptable. The statement should be written on between the signature of one witness and the other, and exception is not possible. 12. When a legal document is written up a portion of paper where there had been erasures and witnesses signed on a portion of paper that had never been erased, the document is not acceptable. This applies even to the witnesses' right. We, the witnesses, signed the portion of the paper that had never been erased, while the document was written on the portion where there were erasures. So the rationale that we fear the person in possession of the document will erase it in the second time, write on anything that he desires, since the document as a whole has been erased twice. The forgery will not be obvious. If by contrast, one portion of the document had been erased once and the other twice, the distinction could be made. Among the prevailing regulations for legal documents is to carefully scrutinize documents, seeing if the Vaven and the Zayin are not squeezed between the letters, lest the person have forged this letter, adding it to the document. Similarly, the letters must not be too far from the other letters. The word is the person have erased. The person have erased a portion of one letter, e.g., a ches or a hey or ches, and left one of its legs in the place of a vav. Similarly, in analogous situations, we scrutinize the text in any language and with any character. 13. The number of from shalosh 3 to esar 10 should not be written at the end of a line, for it is possible for the person in possession of the document to forward the text to make the shalosh shlashim and the esar esrim. If it would happen that a scribe would have to write these numbers at the end of a line, he should repeat the text of the document several times till the numbers come out in the middle of the line. 14. When the upper portion of the promised note speaks of mana, the lower portion speaks of 200 zuz. The upper portion of the promised note speaks 200 zuz, and the lower portion speaks of mana. Everything that follows what is written in the lower portion. Why do not follow the lesser of the two numbers? Because in this instance, one is not dependent on the other. The promised note said owes a mana which is 200 zuz, or 200 zuz which is a mana, the lender would be granted only a mana. However, there are two manners stated in the document. The latter portion is not dependent on the former portion. We follow the latter portion. One is the upper portion of the legal document. When the upper portion of the legal document mentions one name and the lower portion mentions the name that resembles it, we follow the lower portion. If so, why do we write that portion? So that if one letter of the lower portion is rubbed out, we can learn from the upper portion. If, for example, if the upper portion is stated Hanani or Anani, the lower portion said Hanan or Anan, we can assume that it is referring to the person named in the upper portion. This applies regarding only one letter. We not, however, resolve without regarding two letters in the lower portion from the upper portion. 15. If the upper portion of a promised note speaks of a cephal and the lower portion speaks of a kefal, we follow the wording of the latter portion, for a kefal is less than a cephal. If the upper portion of the promised note speaks of a kefal, the lower portion speaks of a cephal, we suspect that perhaps the fly caused the left leg of the kuf to be rubbed out and made it appear as a sanach, hence the beer may expropriate only a kefal, the levels for measure. Similar principles apply in analogous situations for the beer of promised note has the weaker position. An incident occurred concerning a promised note that stated 601 zuz. To raise doubt, what was the intent of 601 zuz? Or was the intent 600 ishtara and 1 zuz? So just said the bearer of the promised note may collect only 600 ishtara and zuz. For the bearer of the promised note was the weaker position. If so, why did they not say that he should collect 600 prutas and zuz? Because the scribe would count the prutas as zuzin before composing a promised note. Similar principles apply in all like situation in all times and all places. We follow the accepted norm. 16. When the promised note states ishtara 100 mea, which is plural of ma'al, or 100 mea ishtara, one should follow the lesser of the phrases. The person should receive only one ishtara. The rationale is the bearer of the promised note is the weaker position because he is trying to expropriate property to my colleague, and a person expropriate property only when there is no doubt regarding his claim. Similarly, whenever a promised note could be interpreted neither of the ways, either this way or that way, the bearer receives the lesser of the two amounts. If however he seizes possession of the greater amount, the borrower may not expropriate the money from him unless he can clearly prove the legitimacy of his own claim. 17. When the promised note states a golden coin, we assume that the intent is no less than a golden dinar. If it states gold of dinarum or dinarum of gold, we assume that the intent is no less than the value of 2 dinarum of gold. If it states dinar, gold in dinarum, we assume the intent is no less than a value in gold of 2 zilver dinarum. Similar laws apply in all analogous situations. But at the time, blessed be God who grants assistance.